regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with us on the program today. Join me on the show, Stephen Gutowski, founder of The Reload, who has been doing some excellent reporting on what's going on over at YouTube, where a large number of vloggers who deal with Second Amendment issues, including getting in some range time, recently found their channels under fire, right? For, we don't exactly know why. Supposedly this was a mistake, but we also saw some folks who had their accounts restored all of a sudden go back down on Friday. So Steven's got an update, and I'm very, very pleased that Steven could be with us on the program to talk about the latest attack by Big Tech. Take a look and a listen. Steven, thanks very much for coming to the show. It's good to see you again, sir.
Hey, thanks for having me. It's good to do another one of these crossover episodes, the across the universes, like a Marvel DC thing.
Well, I do love coming on the Reload podcast. I always love having you on here. And a little bit more of a crossover. I saw the latest Reload podcast. You were talking to Larry Correia. We also spoke with Larry for Cam and Company recently about his book, In Defense of the Second Amendment. So there you go. I would encourage folks to check out the Reload podcast every week in addition to Cam and Company. But I also want to talk.
He's been all over the place, by the way.
He has been, which is good to see.
Publicist.
Yeah, right.
But good book too. You know, I thought it was valuable. So.
Yeah, I did too, and Lord knows we need it because the Second Amendment is under attack right now, so we need defenses of the right to keep and bear arms, and not all these attacks even are coming from lawmakers or even directly from gun control advocacy groups, right? You were reporting on something that happened on YouTube, and this goes back, I mean, it goes back more than just last week, right? This is something that a lot of the gun vloggers have been complaining about, that they don't really know what the rules are. But all of a sudden, a lot of videos, and in some cases, entire channels, just started getting deleted. And you were able to trace this back to the commonality was that they all had silencers in these videos.
They all had silencers. The guess was, at least, that they all had silencers that were being attached to the ends of barrels. So they're being, screwed on to a gun, essentially. So it wasn't just that you had a silencer. It was that you attached it in the video. People, there was sort of one of the big problems, obviously, with large social media sites like YouTube and their moderation practices is that they're often extremely vague and often intentionally vague. The argument goes from these companies that if they tell you exactly what the rules are, then bad actors will find ways to get around them. And it's kind of a parallel there between moderation policies and a lot of gun control laws, right? The sort of loophole argument that if you're following the rules but doing something that some people don't like, then you're exploiting a loophole, right? And so that's kind of the idea at the core of a lot of these things. They don't want to tell you exactly what you can and can't do, because then you might do something that is what they don't want you to do, but still allowed. So instead, they go with sort of vagaries. And, there's, of course, the other problem that reading through the YouTube guidelines, it's very clear that the people who write them don't know very much about firearms to begin with.
Yeah.
Another similarity to a lot of gun control laws, if you think the assault weapons bans, for instance, it's pretty clear that people who write those don't really know much about firearms. And so you get these situations where it seems as though screwing on a silencer or suppressor to the end of a barrel or attaching it in whatever fashion. Obviously, there's a couple different ways, a couple different methods out there, but that was deemed to be modifying a gun. That was what people assumed, at least from reading through the rules and from the strikes they were getting. And these weren't, mind you, these weren't like, we're going to demonetize your video so you won't get ad revenue from it, or, we're going to take the video down because it doesn't apply with how we're interpreting our rules now. These were channel strikes, which on YouTube you get 3 strikes and then they delete your entire channel and you can't do anything about it. Yeah. So that happened to several people, to several large companies, Silencer Co., AmmoLand, There were a number of significant channels from major players in the industry that had their entire channels deleted over this new interpretation of a policy, it seems like. And then, it turns out that according to YouTube, this was a mistake on their end. So they've reversed these strikes and channel deletions, but I think a lot of people are still left with a lot of confusion and distrust.
I think so too. And in fact, I mean, it seemed like I think Friday afternoon, John Petrolino, one of our contributors at Bearing Arms, was talking to one of these vloggers who had his account restored, and then all of a sudden it went back down again Friday afternoon. And so, I think there was still some confusion. There's going to continue to be confusion, particularly again if YouTube. And this is not just YouTube, by the way. I don't want to say this particular case deals with YouTube, but I think, as you say, a lot of these policies, these sort of intentionally vague policies, a lot of social media companies have these sort of policies, right? So it's not just YouTube. It may be Instagram. It may be Facebook. And, it seems to me like that's not going to change, right? If that's the attitude, that we want to keep this as vague as possible so that we can avoid the quote unquote loopholes, that this is an issue that's going to continue to pop back up, and gun owners, particularly those, again, in that social media space, we're going to have to continue to deal with this going forward.
Absolutely. I mean, the thing is, they may have reversed themselves on this particular policy, and it's not entirely clear why. Maybe it was a genuine mistake. It seemed to be something that was more systematic than that. Obviously, these large companies, their moderation teams are huge, and there's a lot of layers to them. So maybe some middle layer made this decision, and then when they started getting complaints about it, or media questions, a higher layer up was like, never mind, this is a bad idea. It's hard to know exactly. Maybe they're worried about congressional hearings. This is another factor now. There's a law in Texas that is a new approach that sort of tries to force companies to change their moderation practices by law. Opens them up to liability. So maybe part of that was the consideration too. But I think it is important to keep in mind as well that the policies on YouTube are already quite strict. You can't, for instance, you can't even mention places that sell guns. Like, you can't tell people, if you're a YouTuber, you can't be sponsored by like Bud's Gun Shop or Cabela's or something and tell people to go buy guns there. And that's true for pretty much all social media sites. So that, even though there's nothing illegal about that whatsoever, and it's extremely, it's just like telling someone to go buy a grill at a grill store. Like, there's nothing illegal about any of this. You can't even do stuff like that. And there's far more limitations than just that. And so, it's likely going to continue to be a significant issue if you're trying to either make content for these platforms, like, you and I do, and a lot of other people do. A lot of people with 10 million followers, subscribers. Demolition Ranch, for instance, on YouTube, very popular YouTube channel, 11.2 million subscribers. He was affected by this too. He had a video taken down, which has since been restored. But it just gives you an idea that this was across the board. It was huge accounts and very small accounts. I got emails from them too, and I don't think that YouTube is going to suddenly, just because they reversed this particular, whatever you want to call it, policy mistake, doesn't mean that their new rule, they're going to change the rules to be more understandable or friendly towards gun creators. And that's something that everybody has to keep in mind. It's something that has been an ongoing fight that, a lot of these channels are turning to alternative hosting methods. There's Utreon and Rumble. You see Ian McCollum from Forgotten Weapons has tried this for years, complained about the policies and tried to find alternatives, but it is hard, right? YouTube's the largest by far.
Yep.
And it's understandable why people want to reach that audience.
Absolutely right. I mean, that's always the conundrum there, right? You want, if you've got this 800-pound gorilla, and they've got these policies that I think are detrimental to in this particular case, the Second Amendment or gun vloggers. You might be able to find a place that has policies that are better, but they don't have the footprint, they don't have the numbers, right? And so you lose that audience. But listen, I mean, as you say, I think this is part of a much broader effort that has been underway for a long time, but I think it's been ramped up since Bruin to denormalize gun ownership and to denormalize, the tens of millions of Americans who are exercising their Second Amendment right. They want, I think, the gun control advocates, and unfortunately, I think that there is the tech space is weird because you've got a lot of libertarians in there, but you also have a lot of, I think it's fair to say, anti-gun progressives who I think are in a position to make some of these policies. And I think that they are willing to do whatever they can with these platforms, again, to push gun ownership to the margins, to push it to the fringe, right? To make it seem like it's something dangerous and verboten that shouldn't be spoken of. As opposed to, I don't know, providing an education and training and actually normalizing the exercise of a constitutional right. Yeah, this isn't going to disappear and it's not going to change. This is one of the fights that we face. And again, we're talking about private companies. So, I mean, unless maybe you could make some sort of antitrust argument, I don't know. These companies are look, they've got broad leeway to set their own policies as far as content moderation. At least at the moment, as you say, state legislators are getting involved, and then we'll see what happens there. But this is a fight that's going to continue. Speaking of Texas, though, I want to talk about a decision out of the Fifth Circuit Court of Appeals for a moment or two that does implicate Texas. Texas is in the Fifth Circuit. This was that decision that basically said those subject to a domestic violence restraining order should not be barred from possessing firearms, right? That federal law goes too far, that there are no historical analogs. And what's really fascinating about this case, Stephen, when you read that opinion from the Fifth Circuit, there was an Oklahoma judge actually who on Friday, I think, declared that the marijuana policies are also in violation of the Second Amendment. And the common theme there is that there is no limiting principle on the part of the DOJ right now, that they're basically arguing if you get pulled over for not wearing your seatbelt, well, you're no longer a law-abiding citizen. And so therefore you've lost your Second Amendment rights, hypothetically speaking. Now, in these particular cases, that's not the law being challenged, but you've got multiple federal judges now pointing out that DOJ's position is basically any violation of any law, no matter how minor, separates you from your right to keep and bear arms.
Yeah. Yeah, and that stems from this argument about who the Second Amendment applies to, right? Because it's the right of the people. And so in Bruin and Heller and McDonald, the court had talked about at points law-abiding people. And so the DOJ is trying to argue that only essentially non-criminals are in that group that's protected of the people. Like they're trying to make this argument about certain kinds of people fall outside of the political protections provided to the people. And so the courts thus far, as you noted there, have rejected that idea, although you have seen some. There was a district judge in Texas that ruled, he ruled against you might remember this one, I'm sure a lot of your audience remembers the one. It's the felony indictment ban on receiving guns. He ruled against that law. Mm-hmm. Because basically sort of somewhat similar to this restraining order issue where these aren't, an indictment is not a conviction. A restraining order is not a criminal conviction. It's a civil proceeding. There were some, I would say that the restraining order issue, there were a couple of historical analogs that got a little bit closer than what you've seen with some of these other laws like the assault weapons bans or magazine bans. The surety laws were civil. They did prevent people who were accused of being dangerous individuals from carrying a gun without posting a surety, a bond, or sort of insurance. But obviously, the court in the Fifth Circuit ruled that punishment is different enough from the restraining order gun ban, where you can't possess firearms, that it's not a close match. That might be a key point as this case moves along. We'll see. But basically, that judge who ruled the felony indictment gun ban on receiving guns or obtaining guns was unconstitutional. He later ruled that the felony conviction ban was constitutional because felons fall outside of the protections of the people historically. So like for instance, felons can't vote. You know, that's a common restriction on somebody who's convicted of a felony. And so you have this sort of base idea of like, who does the Second Amendment protect? Is it just every American, which is what the Fifth Circuit basically ruled, or is it only certain, you know, law-abiding people, like the court sort of mentions, but doesn't? The court, of course, never ruled that only somebody who's never had any trouble with the law is protected, because as the Fifth Circuit goes at lengths to point out, like you said, there's no limiting principle to that. It's somebody who has a bunch of parking tickets, not law-abiding. You know, where's the line? Like, domestic violence restraining order, you might get a lot of people to say, yeah, that's not a law-abiding person, perhaps. But where, you know, DOJ didn't provide any sort of line for where that ends.
So I know that this is something that you write about in the newsletter at the Reload, and I would encourage folks to sign up and subscribe. But give us just a little preview of what's behind the paywall here. What do you think the Supreme Court is likely to do with these cases when they eventually get there? Obviously, it's not imminent, but Garland has said that he will be appealing this Fifth Circuit decision. Is this an issue you think the Supreme Court is ready to wade into? Do you think they're going to, you know, because there is, I think, now a bit of a split in the circuits, maybe not a formal split, but you know, do you think the court is ready to weigh in, or do you think they'll continue to let this particular issue percolate in the lower courts a little bit longer?
Yeah, I think that's a really key question. Usually when the government appeals a decision like this, where the practical effect is that federal law doesn't apply in the Fifth Circuit right now on this question, whereas it applies everywhere else in the country. And the federal government and the Supreme Court don't usually like to let that stand for too long. The main things that will be, you know, impediments to getting to the court immediately are that this was a panel decision. So you still have the en banc court to consider. Like, if the government wants to appeal, they can take it to the full Fifth Circuit and see what they say. And then the other issue is, as you alluded to, there is a circuit split in the sense that, you know, no other circuit has found this law to be unconstitutional. However, I don't believe there hasn't been another appeals court that's considered this question after Bruin. So the court might, and in this particular situation where I think it's a closer call than, you know, some of these other issues that we focus on, you know, some of these other modern gun laws, I do wonder if the court's going to want to see how other districts approach this question. Like, what are there going to be good reasons that fall in line with Bruin to say that this law is not unconstitutional? That's where you might see the court want to wait a little bit. But if it does get there, you know, one of the things that I do wonder is whether they might reverse this ruling, because as much as it seems to be pretty well in line with Bruin, right? You know, the logic used in the Fifth Circuit's reasoning is pretty sound, I think. For a lot of reasons. You know, a lot of these historical analogs aren't really exact matches, you know, for the purpose of the law or the means by which it tries to accomplish that. And so, you know, it may well be the right outcome under the Bruin test. But the thing about the Supreme Court is that there are practical things at play, right? The court to this point has not struck down a gun law that was really popular. You know, it struck down bans on handguns in the late 2000s, which by then there are basically 2 handgun bans in the whole country, right? Chicago and DC. And same thing with Bruin for gun carry. Like, the country had, you know, 40 years ago, had basically total ban on concealed carry everywhere. And by the time the court got around to it, no one banned concealed carry at all. And then you just had those 8 states that were may issue, which had these restrictive laws that were, you know, somewhere between no carry and shall issue, right? And so the court has not been at the forefront of these issues. They really have been waiting until the public comes around on certain issues. And I don't know that, you know, domestic violence and gun ownership is obviously something most people don't want people to have guns if they committed some sort of act of domestic violence. Obviously, this issue deals with a restraining order rather than a conviction. As I said earlier, I think that's a key distinction that the court might also, these other courts have found this to be a pretty important thing, and the Supreme Court might feel the exact same way. But, you also have the court mentioning, machine gun bans are not implicated by Heller, neither are the felon in possession bans. You got that concurrence in Bruin from Roberts and Kavanaugh that say shall issue permitting is fine, even though they don't go through and do a historical analysis like Bruin requires to explain why this law is fine as part of the tradition. So it's a little more up in the air than I think people might imagine.
I think you're right. And I think one of the underlying debates with this particular topic goes back to Kavanaugh and Barrett and, their belief, I think, in previous cases that maybe the wrong standard is being used, right? Maybe it shouldn't be that, well, all felons are prohibited from possessing firearms, even nonviolent felons. Mm-hmm. But, violent misdemeanors, with the exception of domestic violence misdemeanors, are not prohibited. Justice Barrett has talked about how the historical standard really should be dangerousness, right? That's the proper historical standard to use. You could still have people who would be prohibited. But again, it wouldn't necessarily be, based on, well, you were convicted of, felony welfare fraud 20 years ago, so you can't own a gun, which I think was the charge in Cantor versus Barr. And you're right. I don't know that the court is ready to deal with that and to take that on, because that would be it is a very big question. You're right. And it may need to be dealt with based on the Bruin test, but that doesn't necessarily mean that the court is going to take it up right away. Hey, Stephen, listen, I could talk with you for hours, but unfortunately, we are already at the end of our allotted time here. I do want to thank you for being on the program as always. I would encourage folks to check out the Reload.
Go Birds.
Get ready for the big game.
Polls. Let's go.
Yeah, there you go. All right, well, listen, best of luck to the Eagles this weekend, and I look forward to talking again very soon. I do appreciate Stephen sitting down with us for a few minutes. Looking forward to having him back again very soon. And I was on the Reload podcast a couple of weeks ago. You can check that out over at thereload.com as well. Right now, let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We will start there with a disturbing case out of Rochester, Minnesota. A Rochester man was given just 180 days behind bars for raping two young girls. The victim is between 4 and 9 years old at the time. This is absolutely outrageous. This was a week ago. Muhammad Bakari Shai, appearing before Judge Jacob Allen in Rochester, Minnesota, 1 week ago for a sentencing hearing. He was facing 3 different felony first-degree criminal conduct charges in 2 separate cases. But he was offered a plea deal by prosecutors, which called for no prison time, a stay of adjudication, and dismissal of 2 of the 3 charges in this case. In fact, if Shea completes his probation under the terms of this plea agreement, all charges against him will be dismissed and will not be on his criminal record. As the Post-Bulletin in Rochester reported, one of the juveniles in the case was around 9 years old. The other was between 4 and 5 years old at the time of the sexual assaults. And the family members obviously complained about this deal and the lack of consequences. One of the survivors testifying says, "There's no moving on or getting over it. I've tried." Breaking down and crying after giving her witness impact statement or victim's impact statement there before the judge. Shea was between 15 and 16 years old at the time of the sexual assaults. He was originally charged in juvenile court back in 2019. But because of the court closures, thanks to COVID, this case was pushed back to the point that prosecutors would actually lose their jurisdictional authority to prosecute the case. So charges were dismissed and then were ultimately refiled. But he was, again, offered a plea deal that included that stay of adjudication and no prison time in exchange for him not challenging certification in adult court, which allowed for his continued prosecution. He entered an Alford plea in December of 2022, meaning that while he does not admit guilt, he does acknowledge that a jury would convict him based on the evidence. His attorney, James McGeaney, argued that the court lacked the authority to impose any jail time as that was not the, quote, spirit of the plea agreement, and any jail sentence would be in violation of the agreement. And amazingly, the judge, this accounts for getting tough on Mr. Shea, because the judge ultimately agreed with that argument, pointing out that judges ordering stays of adjudication in drug cases routinely impose a 30-day jail sentence. But at most, Shea will serve 116 days in the Olmsted County Detention Center. His jail sentence will begin on February 13th, so he didn't even have to report to jail immediately. He's also ordered to undergo a sex offender program and complete 200 hours of community service, but he will not be required to register as a sex offender, despite, again, allegedly raping a 4-year-old, somewhere between 4 and 5-year-old, and a 9-year-old. Again, you can talk about, the court closures and the delays that were brought on by COVID, the fact that he was originally charged as a juvenile and is now moved into adulthood. I just don't see any way how this deal is going to sit right with most anybody there in Rochester, Minnesota, nor should it, quite frankly. And the excuses, I mean, listen, I get it. There were court closures. There were lots of delays. It impacted far more than just this one case. But again, it doesn't change the fact that somebody says, yeah, this has gone to a jury. They would have convicted me of raping these kids. And now less than 4 months in jail as a result. Today's Armed Citizen story, Billings, Montana, where police say a woman shot 2 men in an act of self-defense in an attack outside of her residence. Police said last week that the 25-year-old woman shot the 2 men, ages 29 and 37, apparently to protect herself. Police Lieutenant Matt Linick said in a statement to KTVQ, as far as the victim using a firearm for self-defense, the law is pretty clear on people's right to use self-defense when they can articulate a threat to themselves or others. Like all cases of this nature, the case will be reviewed by the county attorney's office. They could bring forth criminal charges against the shooter if they deem the threat didn't meet the level of force used. But right now, police believe that it did. Shooting happened about 12:45 last Saturday. Police described the incident, 12:45 in the afternoon, by the way, broad daylight. They described the incident on social media as a possible robbery with shots fired. In a statement, police said the report indicates the suspects attacked the victim in her car outside of her residence. The victim pulled her concealed firearm, and both suspects were shot. One of the men who was shot remained at the scene. The other fled the area, but arrived at a local hospital shortly later. Neither of the men were armed when police ran into them. According to police, due to their injuries, neither suspect arrested or charged immediately, but the case was sent to the county attorney's office for review and official charges. We'll keep our eyes on this story, let you know any details as they become available. And finally today, our good deed of the day, in the right place at the right time, willing and able to do the right thing, an off-duty EMT who was able to save his neighbor's life by using the skills that he deploys on the job. This was in Windham, Maine. Dustin Andrews works as an EMT for Windham Fire and Rescue. And back on the morning of January 24th, he was actually off of work, just driving his family. And he said the car in front of him started to behave oddly and then crashed into the snow that was lining a retaining wall over a bridge. Andrew saw what happened, said he had to pull over. And then he noticed a guy, Rob Parrott, in the driver's seat. At first, Andrews thought he was having a seizure. He said, but once I get access to the window, I was able to realize he wasn't breathing. And that's when I said, all right, he needs to come out. I pulled him out, began CPR, used his pocket knife to actually break the window, performed CPR on Parrott for 7 minutes before paramedics came by. It doesn't sound like he was able to call 911 at that point, but that paramedics drove by and saw what was going on as well. Parrott ended up surviving his medical episode, which doctors diagnosed as a cardiac arrest, and has recovered enough to the point that he could talk to local media. He said, it just blows my mind. I'm still trying to figure out where people were. There has to be a reason. He said the chances that an off-duty first responder noticed he was driving on and then stopped to rescue him are so low that he decided to invite Andrews and his family over to his home this past Sunday so they could meet each other formally for the first time. He said, I did it just to show him how much I appreciate it. And, this is why you do your job. Whenever you get something good, I like to see you recognized for it. So the two were able to, share an embrace and a hug, spend some time together, getting to know one another. Parrot said, just to be here and meet the guy that saved my life. And in my opinion, without his actions, I wouldn't be here today. Well, it's as simple as that. So in the right place, at the right time, willing and able to do the right thing. Dustin Andrews of Windham, Maine. Well, your neighbors already thanked you for your very good deed, but we thank you as well. That is going to do it for this edition of Bearing Arms Camp and Company. But again, I would encourage you, check out bearingarms.com, the website, throughout the day. There is so much going on right now in terms of court action. We've got new lawsuits being filed. We've got requests for TROs and injunctions in federal court in Connecticut. We also are watching what's going on in state houses around the country, particularly in those blue states where big bad gun control bills are starting to pop up. And they're going to be on the move in places like Maryland this week. So again, we'll get you caught up wherever you live, whatever your concerns. And by the way, we'll give you the good news as well, because there is some good news to report out there. If you like what you see in terms of our reporting, I'd also invite you to become a VIP member at Bearing Arms. Just go to bearingarms.com/subscribe. Use the promo code GUNRIGHTS, and you get a significant savings on your VIP membership. As our way of saying thanks for showing your support, we're going to give you exclusive content you won't get anywhere else, because your support does matter, and it really does make a difference. We'll see you back here tomorrow. Until then, be well, be safe, be free.